Okay, welcome to today's webinar. It is on hard money loans and the documents we use on hard money loans. And this is, let's see, make sure I can, there we go. Oh, I don't have my initial disclaimers. So let me go through the disclaimers real quickly that are not appearing on the slide. Remember that this is informational, this is educational, this is not legal advice. And so just listen, be aware, learn, and then if you do have very specific questions about a specific situation that you're in, please call the office and then we can give you a legal opinion as an attorney-client. But this is an educational webinar for your benefit and does not constitute legal advice. Also, Braille Law Office, we do a lot of real estate investment transactional documents. We do asset protection, we do estate planning, and we do our estate planning in conjunction with your asset protection, which is a little unusual. Most estate planning attorneys don't necessarily look at the asset protection side of things, but we do both. And we do title work, so we do closings. And we are able to close very crazy and complicated deals and seller financings and wholesales and things of that nature that a lot of title companies either don't understand or won't even do. So remember us for your both legal and your title needs. Okay, awesome. Here is the schedule for this webinar for the next 45-50 minutes. These are the notes and deeds and things we're going to cover. First, a standard note and deed. Then we're going to talk about a personal guarantee. A non-recourse note and deed, a fractionalized note and deed, shared appreciation notes, which I love, and I actually use shared appreciation notes all the time, and I'll tell you when and why I use them. Modifications, how to modify the note and deed if you have to make changes, that sort of thing. Substitution of collateral, this is also kind of called walking collateral or walking the deed. We'll talk a little bit about assignment of the note and deed. Which is if you're buying or selling paper. Now, this is not a buying and selling paper class. Unfortunately, that is a big topic. But we will talk about simple assignments of assigning the note and deed and placing a notice of interest, which is just another way of sort of securing rights against a property for a loan that you may have made. And at the very end, we'll talk about the licensing requirements here in Utah for hard money lenders. Okie doke, let's get on with the show. First, standard note and deed. The note is really the promissory note. And a promissory note is just an obligation to pay a debt. It sometimes is called a loan document and I've seen a few other names, but it's really just a document. It states out the terms of the loan itself. It'll points and interest. Everyone probably knows what points and interest are. Points are usually sometimes called origination points in the mortgage industry, but as among hard money lenders, the points is usually 1, 2, 3, 4, 5% of the total value of the loan. And the interest is then, and that's paid sort of either at the initial loan or at the payoff of the loan. That depends on the lender. And then the interest is the interest rate you'll pay based on the value of the loan over the course of time for however many days that you have the loan outstanding. So the points and interest, now one thing, how calculated and when due. These are important terms to kind of remember. How is that interest calculated? Is it calculated on a per diem? Is it calculated on a per diem of 365 days a year? Or, and you may see this on occasion, 365 and a quarter days per year. Because remember, there is leap year, so every 4 years we have an extra day. So technically there are 365 and 1/4 days in a year. Is it simple or is it compounding interest? Most hard money loans are almost always simple, which means you pay per diem interest for every day that you have the loan outstanding based on a yearly APR. And that interest does not get put back onto the principal and then upping the principal every day. So the other way to calculate it is monthly. And so if your loan doesn't say if it's calculated monthly or daily, remember some months have 31 days, some have 30, and 1 month, February, can have as little as 28 days. So that can make a difference on loans if you don't know exactly how many days you're using to calculate that interest. So make sure your loan documents state how that interest is calculated, when it's due. When are the points due? Are they due up front? Because many lenders will actually make their loans and they will withhold the points from the loan. So they may give you a $100,000 loan with 2 points, but they will withhold the 2% and only transfer $98,000 to your title company, which means you're only getting the $98,000 for your purchase or your rehab or whatever it is you're doing, because you're prepaying the points. So make sure you understand those terms and how and when they're due and calculated. And then the term. The term is usually, is it 60 days, 2 months, 6 months, 1 year, 5 years, 10 years? That's the term. Payments. Typically, hard money loans do not have monthly payments, at least that I've seen. I'd say 80% don't have monthly payments, but some lenders do require a monthly payment, especially if the loan term is a little bit longer. Quick question, how about a 360-day basis, 365 divided by 360 or 365 divided by 365? I've never seen a 360-day basis. But again, as a lender, you can put in whatever calculation you want. I always put in 365. I think that's the easiest. I don't care about that quarter. I don't like going monthly because monthly some months are longer. So I take my interest rate and I divide it by 365 for a per diem interest calculation, as opposed to dividing the interest rate by 12 and a monthly calculation. So payments, if you do have monthly payments, when and how, just make sure you comply with them. Late fees, make sure you understand those terms. Deadline and extension terms. Remember, that deadline, hard money lenders really like that deadline. That's when they want their money back. Hard money lenders use these loans for short-term basis, not long-term, and they make money by continually flipping over this money. So if they have to extend with you, they're losing out because they can't get the money back and do another deal. Some lenders put in points or some sort of additional interest if they do extend, something that's sometimes it's automatically in the note, sometimes it's negotiated at the time. Usually in the note, there's a statement that this is a secured note, and there's a security statement that this note will be secured by a piece of property, real estate, by a trust deed or mortgage. Most will also say that there's no further encumbrance, which means you can't really take out any other loans. So make sure that you do read these notes and make sure you're a first position lender. If he's got this no further encumbrance on the note, if you go out and take a second position loan, you are technically in breach of this first note and deed. I have seen that on occasion that a hard money lender would put that in there. And many do have a due on sale clause, just like traditional mortgages. Joint and several liability. This is if there are more than one borrower, and each borrower is individually and collectively liable for the full amount of the loan. So if one borrower can't pay it, the other borrower will have to pay the entire amount, even though they're both on it. That's what joint and several means. And most notes will contain a no assignment clause or transfer by borrower, but most notes do allow the lender to transfer the note, and many lenders do. Okay, also look at the default provisions. What happens if you default, if you miss a late payment to the point of default, or if you miss your deadline? What are the fees, what are the penalties? Usually the default interest rate will go up. I've seen them as high as 18–20%. Waiver of notice, this is usually stating that the lender can foreclose without notifying you that they're going to do so. They can usually immediately foreclose. Most options, if it gets to that point, they use a deed in lieu, which means you just deed the property over to the lender takes the property and forgives the debt. That's just a fast way to solve the issue without having to go through foreclosure, which can take a lot of time and a lot of money. But typically, for most investors and most lenders, if you get to the point of not being able to pay off by the deadline, most will renegotiate and modify the note and extend it, do an extension for some more points or a higher interest rate, or very often I see they'll actually make the borrower catch up on all interest up to date and then go under kind of a monthly payment system. Okay, note with personal guarantee. Normally what borrowers want to do is borrow in the name of their entity, their flipping entity or their holding entity if it's a rental. Because as a borrower, you do not want to personally guarantee any note. But as a lender, lenders want a personal guarantee. So this is a point of negotiation between the two. Borrowers don't want it, lenders do. When I do hard money loans, I always get a personal guarantee. It's a matter of course. So most borrowers understand that most lenders are going to ask this. This is typical clause that you'll find on your notes, where if you take out the loan in the name of your LLC, that you as an individual will personally guarantee the note. The reason for this is the hard money lenders know that most investors are, especially in these cases, are flipping, or they're purchasing it with hard money during the rehab process so they can refinance out and hold the property as a rental. And the entity that's doing the borrowing may not have a whole lot of other assets. It may be this the only house that the LLC has. And so if something goes wrong and there's not enough equity in this particular property to pay off the note, then what would happen is the lender would sue the borrower, the LLC, and the LLC would just file for bankruptcy. And the lender would be out of luck on getting anything that wasn't paid off in a foreclosure, for example. And so the lender wants the ability to go after other assets of yours, personal residence or other properties you may hold in other rental properties or in other LLCs. And there are investors out there with a dozen different LLCs. So most lenders will request a personal guarantee. A non-recourse loan. What's typed in black is typical language you'll see in a non-recourse note and deed, which means, and we'll kind of just read through it, none of the borrower, which means the LLC usually, or any director, officer, manager, etc., shall have personal liability under this loan or any other loan document. So this really is the polar opposite of having a personal guarantee. What a non-recourse means is that the lender's only recourse to enforce this note and get paid back is against the property itself. So the only thing they can do is foreclose on the property and get whatever cash out of it they can. And so it cannot go beyond the property. The lender cannot go after the officers of the LLC or personal people involved with the LLC, or even the person themselves if it's just a personal loan. Most lenders don't do this for obvious reasons. They want to be able to go after whoever they can. The area that we see this most often is in using IRA and 401k plans in purchasing real estate. If your IRA or 401k or any retirement account, for all intents and purposes, purchases real estate or for any other reason needs to borrow money. So when your IRA is the borrower, and your IRA is buying a seller finance deal and the seller is carrying a note and deed. So your IRA is technically the borrower because it's buying the property and it's borrowing the money from the seller. That seller's note and deed must be non-recourse. That is to comply with our ERISA rules that the lender can only go after that property and not sue the IRA or 401k. So I threw this in there because that's typically but the only time that I really do see non-recourse notes and deeds is when the retirement account is the borrower. And there are variations of non-recourse. There are non-recourse that are sort of truly non-recourse, and for any circumstance, you cannot go after anything but the property. And then there are sort of softer non-recourse note and deeds where if the borrower commits fraud or does something like takes out an additional loan or commits some other kind of default under the note, in that case, then the lender can go after others. Okay, a fractionalized note and deed. I actually do a lot of these too. A fractionalized note and deed is one note and deed with two lenders on it. So for example, if you're taking out a first and second, kind of a standard situation. You take out a first for the purchase price of the house. You take out a second for the rehab. Well, that second loan is in second position, which means in a foreclosure, auction and sale, that the first position loan must be paid off in full before the second position lender can get any money. That's the first and second position. You probably understand that. What a fractionalized note and deed does is take both of those lenders and puts both into first position with a percentage interest. So let's say there was a first at 80 and a second at 20. So the note is going to say $100,000 because that's the total amount of the loan. Lender 1 has 80% of that note and lender 2 has 20% of that note. So if it goes to foreclosure and the money's being paid out, each dollar that is net, 80 cents will go to lender 1 and 20 cents will go to lender 2. So if it falls short, if the foreclosure sale doesn't bring enough money to pay off the note, then each lender shares proportionately in the loss. This is normally done, it's not normally done with a first and second position lender. I mean, they could, I suppose, but most first position lenders for the purchase price of the house don't want to share the note. They just want 100% in first position. But I use that kind of as an example. And most times when we do fractionalized note and deeds is when the source of money for the purchase is coming from multiple sources. Perhaps a lender has a 401k account and a personal account of cash. And they need both of those accounts to make the full loan. Well, of course, the lender, if this is a first position lender, he doesn't want to take a first and a second position loan. He wants both those loans in first position, so he will do a fractionalized note and deed so that both of his accounts are in first position for that loan. So that's typically where we do these, is when either the lender has multiple accounts they need to draw the money from, and in rare cases where two different individuals might be each putting up part of the first position note and deed, or the first position money. And again, I rarely see fractionalized in second positions, usually because the amounts are so much smaller that most people don't need to do that. The question is fractionalized the same as participated? Good question. I don't know how you're using the word participated. I'm assuming that by participated, you're meaning a shared appreciation where the lender participates in sort of the note. That's how I've heard it. I've never heard the word participate as relating to a fractionalized note and deed. I guess it's a CD. I'm not sure if you're in another state. I do know that, like for example, shared appreciation notes, which is what we call them. Other states would call them shared appreciation mortgages or participation notes and participation mortgages. That's where I've heard that term. Here in Utah, I've only heard the word fractionalized note and deed. I've never heard it as a participation note. So can't help you there, but maybe send me an email. We can chat a little bit more about where you've heard that and maybe figure out where that term is coming from. The big kind of key here with a fractionalized note and deed is both lenders, or all lenders, have the right of foreclosure. So if you do have like an 80-20 fractionalized note and deed with somebody else, and the borrower is getting behind, and it looks like they're not going to, or they are in default, you may want to work with the borrower, extend the note, maybe add a point on and all that, and keep working. But the other lender may say, no, I don't think this guy's ever going to come through. I want to foreclose now. Well, the other lender has the right of foreclosure even without you. So it does, in that respect, act like a first and second where either lender can foreclose. Okay, boom, boom. A shared appreciation note. A shared appreciation note, essentially the lender will charge lower than market interest rate or even a zero interest rate in exchange for a share of the net gain of the property. This is how I generally partner with others in flipping properties, for example. A deal may come my way. I want to take it, I'll secure a first position loan because I've got lots of maybe hard money lenders for first position in my pocket. And then I will contact a partner who's a great rehabber, can get in and fix things up in 30 days and get in and get out of there at a great price because it's what they do. And so, but I just don't want to loan money because then I'm making 2 points and 12 interest, or maybe 4 points and 14% interest, which is a great return. If they can do it in 3 to 6 months, you're still looking at 18 to 25% ROI. So I would do those all day long too. But if I've got a little bit stronger position because maybe I found the deal or something like that, I want more bang for my buck. And so I'll put in the rehab, the second position rehab loan, and secure it with the second position deed. But instead of a rate of 4 and 14, I'll just say I'll take 50% of the net profits. And for my partner, it's great because they're putting up zero cash. So even half profits is an infinite return on investment because they haven't put up any money. And this way, I get a little more control over it rather than just as a lender. I do kind of take more of a role as a partner. I let my rehabber really do what he does best, but I do kind of share in some of the decisions, or at least keep an eye on things. This is, again, this net gain. It works just like an interest, and so it's a deduction to the borrower, and usually the partner that I partner with is the one that actually buys the property. And because he buys a property, it's in his LLC's name, he's going to sell it. And when I do my payoff to the title company, I just say my payoff is 50% of net proceeds. And it works great. And it really, really works great when you're using retirement accounts. And because of this, and at the end of the lecture today, the webinar, I'm going to talk about a live class that I have coming up on retirement accounts and self-direction. There are prohibited transactions. There are types of deals your retirement account cannot do. This is a way for me to be just a lender in this situation, as opposed to a kind of a true shared partner, and perhaps in a shared LLC or something like that. And it can be used to avoid some prohibited transactions. The downside is, you're thinking, great, this is actually interest payment, which is taxed lower than capital gains, or short-term or long-term capital gains, or even ordinary income. And we would love to call this always interest. Now, that question I will leave up to you and your accountant, because the IRS could argue that this is ownership in a debt finance property, which means it's going to be short-term capital gains or possibly ordinary income, because you are really sharing in the profit as an owner, not just an interest rate as a lender. There's not a lot of clear guidelines on that, and it probably depends on how much you're doing and how often you're doing it to kind of depend on how it's going to be termed or deemed by an IRS. But that is something you do need to know with using shared appreciation notes. Is talk to your accountant and say, look, I did a loan, but instead of getting 12% interest, I got half the proceeds, and let your accountant and discuss that with you on how to define that on your tax return. It could also be argued ownership for liability purposes. I've seen no case law on this, and I don't think it's a huge risk. But for example, if something happens on this property while you have the shared appreciation note on it, and a contractor slips and falls on something, kills himself, and the property owner is sued, which is your partner, and their LLC that is sued. If the plaintiff saw that you had a note on there and that it was a shared appreciation note and you got half the equity, they may try and argue that you had ownership and that you are also liable for that, which is one of the reasons that I always loan money out of an entity and not out of my personal name. That is a great kind of nugget information to take away on this. Paying people with cash that make loans, it's just my cash, it's no risk. And for the most part, that's true. There is no risk, other than the loan itself, when making hard money loans. But if you do shared appreciation notes, there may be some kind of liability that might creep up. So for that reason, I just set up an entity, very simple entity, that I do my loaning out of. So in the event there is liability, I've got that LLC for protection. One of our listeners says, I use an exit fee for a % of the net of the profit. So another great strategy, using an exit fee. I've never done that, but I've seen others who have done that. And again, it's a way of getting a percentage of the profit as opposed to just an interest rate in those situations. So great tip, using an exit fee for a percentage of a profit. Okay. Modifying notes and deeds. Here are the terms you're going to see in a deed. There are terms in the note and there are terms in the deeds, and they're different words. And I know this can get really confusing at why we don't use the same words throughout. We just don't. In a note, you usually have a lender, a borrower, and a title company, right, that are involved. The property, which is also the collateral, a loan amount, the rate, the points, the term, and then some other terms such as maybe balloon payments, etc. Those are all in the note. The deed is the instrument, the legal instrument that secures that note against a piece of property. It's collateral, as collateral. So this is your security. And so the deed uses slightly different terms because it is actually, at least here in Utah, a trust deed, not a mortgage. We're a trust deed state. And trusts have different words. The beneficiary is the lender. The trustor is the borrower. The title company, or sometimes attorney's lawyer's office, will become the trustee. Okay, and the deed must have all three of those. It must name a beneficiary. It must name a trustor. It must name a trustee. It must name the collateral. Here in Utah, by at least the legal description and the tax ID. You need at least both of those. I always stick the property address on there. That's for my references, so I know which deal it's going to. And I tell you, when I search trust deeds and even warranty deeds on county records, or I get them, I so appreciate having that address on there. It just makes everybody else's life a whole lot easier. So go ahead and stick the property address on your note and deeds, particularly your deeds, because that's what other people will probably look at because they're recorded with the county. Here's a side note on recording the deeds. And I bring this up because this is the 4th time in less than a year I've had clients become hard money lenders and loan money to other individuals, other investors. And the other investor gave them a note and deed. The note said there was a secured promissory note, listed an address, gave the terms, and they also gave them a deed with the beneficiary, the trustor, the trustee, the collateral, the legal description, the tax ID, etc. But that deed was never recorded. And the investor who made the loan, they were a newer investor, didn't understand how that worked, thought they had a secured interest, and it was secured by a deed on a piece of property, and they were secure when in fact they weren't. There were times when those notes went into default, and it wasn't until they came to me that I ran a search and realized that they weren't recorded. Some were against properties that the borrower no longer owned. They had properties that actually gone through a foreclosure. And there's some listed properties that the borrower never owned. So again, if you're loaning money and you're new to loaning out money, don't rely on the borrower to do your work for you. You do it. You create the note, you create the deed, you create escrow instructions. We'll talk about that a little bit later. You get it to an actual title company who will actually record it. And when it's recorded, it will be stamped in the upper right corner by the county recorder. So make sure you see that stamp. And it's always my suggestion, if you're in first or second position, to get a title insurance policy. I have had clients had to call in those policies before, so it does happen. It's not a lot, it's not a big risk, but if you're in first or second position, I almost always recommend getting a lender's policy of insurance. That way, you know the title company ran a search on the property. They can guarantee the position that you're in. And if there's something wrong with title on that property that destroys the value, you can recover your money. So again, make sure you record your deeds if you're a lender, and those are recorded. And always use a title company. Do not rely on your borrower to do this work for you. So anyways, those are kind of the terms that you can modify. A modification is actually quite an easy document. You want to repeat all those original terms that we saw up here. So just make sure you list all of those. And I have actually also started using a loan number on my loans, simply because it helps me track them. So if you're a lender, start using a loan number. Just make it up. Just pretend like you're a bank and create a loan number. You can make it like 10 digits long to make people think you give out millions of loans. But it'll help you if you create loan numbers, and then when you do a modification of that note and deed, you can refer back to the exact note and deed, because most modifications that I see will list the date of the note, the borrower and the lender, and the property. Sometimes not even the property address. So again, it's the more information you put on the modification so that you know what you're referring back to. And again, you can change any of those terms. You can extend the term from 6 months to a year. You can increase the interest rate. You can add monthly payments. You can force them to get caught up in interest, and all of that. And all of that doesn't require recording a new deed. All you got to do is modify the note, have the borrower and lender both sign it, and that modification is effective. When you probably do want to record a modification of the deed to and record that modification is if you are upping the loan amount. Because again, and you may want to get another or an additional insurance policy, because if you up the amount, one, you want to put others on notice of how much your note actually is, so that other possible lenders can see what debt is already on the property. And you want to make sure it's insured to the full amount of the amount owed. And so if you're upping the amount, then I would always recommend going back to the title company and recording a modified deed to show that higher amount and making sure that you're insured for the higher amount. I don't see that a lot just because it just doesn't happen. If something happens and the borrower needs more money, like on a first position note, usually they'll refi it completely and get a new lender to come in and buy it out. And that can affect the position. If you do modify the deed, that can affect the position of the deed, which again is why you want to go back to your title company and have them do a search and make sure that they can guarantee that you're still in first position and that you're insured for the entire amount. Okay. When writing modifications, it's really an art of making sure it's clear as to what your intent is. That's really the key of writing a modification. If the borrower is making a payment to get caught up, you'll probably, to get caught up on interest up until that point, you may want to include that in the modification, just so that it's clear that the borrower has made, the first 6 months of interest, and that the new interest starts from that day forward. So that it's, at the end of the term, when the note's finally paid off, everybody is clear that the first 6 months of interest were already paid, so they only owe the additional months of interest and not the whole thing. So, then again, that's something that comes with experience. If you become a lender and you do a lot of this, you'll become good at it. Feel free to call the office. We're happy to kind of go through that with you and or do those for you. And again, I said, usually you do not need a new deed unless you are changing the loan amount. That's about the only time we do a new deed or a modified deed. Substitution of collateral. This is walking the collateral or moving the collateral from one property to another with the exact same note. So you have a note and deed on a property. Let's say you just bought a property, seller financing, and the seller carried a note. And let's say you've got a lot of equity in that property, but you still have a note on it. And you need to take out a big loan. And you've got a lender that will give you this big loan, but they want it secured on one property and one property only. And you've got another property free and clear, let's say, but it's not enough to cover your new big loan, but it is big enough to carry your current loan. You can move the original loan from the first house over to the second house, which then frees up your first house, which is more valuable, and then you can secure a new loan with a higher value on that original property. That's one way to sort of reason to walk a note, because it can free up equity for additional loans kind of thing, if you're kind of going the leverage route. There's a number of other reasons. I actually had lunch yesterday with some clients, and we sat and sort of strategized other ways of substituting collateral to sort of move up and things. And so it's kind of an interesting thing. It's kind of beyond today's scope, but definitely something that if you do a lot of loans and maybe seller financing loans, this is maybe something you want to start including in your notes and discussing with your sellers or your lenders to put this ability to substitute collateral. The walking language, and it's kind of specific language that allows the borrower to substitute collateral, needs to be in the original note. Then when you go to walk the collateral, you'd have to do a modification of deed, obviously, because you're changing the legal description. That's one of the things on the deed, and it's a new property. So again, my suggestion is go back to your title company, tell them you're substituting collateral. They will do a search on the new property, and they will probably issue an endorsement or an allonge, or they may call it a rider. Usually it's called an allonge or an endorsement, that will ensure this note and deed on the new property. And again, it's just something you want to make sure that you maintain your lender's insurance. Your lender's going to want that. That insurance is maintained as you move that note and deed from one property to another. The borrower usually notifies the lender, hey, I'm going to move property, move the collateral. The walking language usually includes that it will be in as good or better position on the new property, and it will be fully secured by equity in the new property. Those are two basic terms that are in the walking language to comfort the lender that they will maintain at least in the position they were originally in, or better position, and that there's enough equity in that new property to cover the entire amount of the loan. Good investors will also provide comps and other information about the new property just to make the lender feel comfortable. But this is a great way if a lender, like a seller financing person, wants nothing more than an 8% return. They don't care what you do with the money. They just want to collect their 8% every month and be happy. And so you can actually move that note from property to property to property and never have to pay off your lender, and then you've got this money to use. These are sort of, we're kind of, it's 12:40, so I want to make sure we keep going. Just, if you want to do substitution collateral, give the office a call, because we've done that for quite a few clients. And then when it does move, they will reconvey. It's called a partial reconveyance because the deed is not completely reconveyed. It's a partial reconveyance as to the first property, so it's free, but then it's still conveyed or liened against the second property. And again, always do this through a title company that understands this, so that you can maintain that insurance. And different title companies have different policies about how they insure these kinds of transactions. The question is, does the walking language need to be in the original note, or can it be renegotiated after you build rapport and trust with 1 year's payments? Yes, you can. But the recommendation is to always kind of put in there in advance, but it can be renegotiated later and modified. And your title insurance company may have issues or questions with that because it will become a different kind of, it may become, depending on your title insurance company, may become a different kind of policy that's issued on it. So check, ask your title company what their policies are on to make sure, because that's the big thing for your lender. The lenders, the only thing they're going to care about is that it's secured against a good property and that they are continue with their policy. It may be that if you renegotiate it, that the title insurance company may do a new search on that property and issue a new kind of policy. So you may have to pay for an additional policy at that point, but it can be done. Okay, here's some language. And by the way, the PDFs of the slideshow is on the website. In fact, we are in the process of sticking the PDFs of all the slideshows for all webinars and all live events on the website next to the videos. All of these are recorded and put up on the website, and they have been for years, but we're actually getting to the point where we're actually sticking the PDF. So if you don't have a copy of the PDFs of the slideshow, you can go to the website, go to the webinars page, and you'll see it right there. So this is the language that we use in substituting the collateral. Assigned in note and deed. This is something done by the lender, and the lender wants to sell the note to another lender who's going to take it over. So this is essentially buying and selling notes. Not done commonly here in Utah up until recently. Every sort of local real estate investors groups have their different focuses and their different education levels, et cetera. And buying and selling notes is kind of a newer thing here in Utah. I have a lot of lenders doing it. They are actually, especially lenders that have access to a lot of borrowers, so people who always need money, and they want to loan out a lot of money, but they don't have all that cash themselves. So the borrowers come to them. This lender loans the original loan, 2 and 10 or 2 and 12 or whatever their points and interest are. And then that lender will assign the note and deed to another lender who really just wants a good 10 or 12% return on their money. And so the first one collects the points and maybe a month or two of interest, then sells it, usually at its face value plus the points and interest, so that the first lender makes his money back, it's his cash back, so he can do another loan. He collects his points and interest for a few days or weeks. And then the new lender has a note that he can just continue collecting the 10 or 12% interest on. And that new lender, the benefit to him is that he didn't have to find the borrower, he didn't have to go through closings, he didn't have to write the loan documents, he didn't have to do anything, because there's already a relationship between the first and second lender. It's like when mortgage companies sell their loans on the secondary market. There's one lender that's really good with finding the borrowers and placing the money, and then there are other lenders who just want an interest rate return. When a lender does assign the note and deed, this modifies the note by changing who the lender is, and it also changes the deed, because remember, the lender is called the beneficiary on that deed, and you now have a new beneficiary who can foreclose. So in this situation, an assignment of a note and deed, the new deed is recorded on the property. It will not change the position of that deed, but the modification of it will be recorded so that future people will know who the beneficiary or lender of that is, and who to call if they ever need to get in touch with the lender. So that one is a recorded document. Okay, a notice of interest. A lot of people will loan money and not secure it, and then little ways down the road they realize, ooh, maybe I should do this. You can do a trust deed, and even get it insured at that point. But sometimes, if it's not a lot of money, these may have been smaller personal loans, or these may be partnering situations where one partner owns the property and they have a joint venture agreement, and the partner that doesn't own the property is putting up some cash. And even though the joint venture agreement says that the other partner, the lending partner, will recoup their money that they put up and then get half the proceeds. That's what the joint venture, that's a contract that stipulates who gets what at closing. The other partner just may want more security. They don't want to own the property, because owning the property could screw up selling the house retail to a retail buyer and changing title and seasoning requirements and all of that. And so the second partner will simply put a notice of interest against the property to secure her rights, any money that she put up and her 50% interest during this joint venture, because her partner is the one that owns title. So that's a very common usage of a notice of interest. It's a cloud on title. It must be resolved before that property is sold, so a title company will have to remove it. It can secure your rights to a loan or any other interest on the property. It does not have to state an actual amount. It can be pretty general. But you can only put a notice of interest on land if you have a written document that states that this written document creates an interest in land and identifies that land by preferably legal description. If you had just an address, I'd still probably feel comfortable doing it, but preferably a legal description. You cannot throw a notice of interest on somebody's property without this written document. That's called a wrongful lien, and you could be subject to many, many penalties, up to treble the amount that it takes to remove that wrongful lien. It's a big deal. Do not put notices of interest when somebody owes you money. Maybe you're a contractor, they didn't pay you. Just don't go throw a notice of interest on. You can do a mechanics lien if you jump through the right hoops, and you can do if you're a contractor, and you can do a notice of interest if you have this written document. About 3 or 4 times a year, I get a client who says that somebody, the last one was a house cleaner. The house cleaner put a notice of interest. And house cleaning doesn't even qualify under a mechanics lien statute, but she put a notice of interest on this property. And he called me up and he said, hey, I paid her. She's trying to get more money out of it. Now she's put this notice of interest on and I can't sell the house. Well, I put on my lawyer hat, my tough lawyer hat, talked to her, had a very terse conversation with her. She tried to deny that it was a wrongful lien. She tried to do her own research and said she talked to lawyers and everything was fine and she could do it. I'm like, no, you haven't. And she finally got the answers that she didn't want to hear, and she sent me an email back. Bad news for me, I'll remove the lien. So be careful of notices of interest. Because if it's wrongful and you put it on a client's property, I will come after you. And I do it all the time. Escrow instructions. These are very basic instructions to your title company, and many lenders don't do it. And I hate, as a title officer or escrow officer, I hate this. Please, if you're a lender, create a form for escrow instructions and provide it with your note and deed, please, because we have to have it. Sometimes if I don't get it with the note and deed, I will ask the lender to send me an email listing some of their instructions, just so I have some written instructions. But typically the instructions should say, you have searched the property and you know that that my deed will be secured in first position or second position, that the borrower has obtained homeowner's insurance, that you will or will not provide a lender's policy, and these sort of things. These are just sort of conditions that you want, as a good hard money lender, you want to be able to provide to the escrow officer, because all we can do is follow your instructions. If you don't give us instructions, we can't do anything. That's a law. That's state law. If you don't tell us, we can't do it. So create escrow instructions. If you're a lender and you don't have escrow instructions, I will happily send you mine for free, the form that I use on my loans, and you can modify or adapt however you'd like. But because a lot of investors have private money, I've had a question earlier of what's soft money versus hard money. Again, that's from CD. Maybe a word used in your locale that I haven't heard here. Private money, at least as that term is used here in Utah, is when you've got a lender in your back pocket that just kind of gives you money when you need it. Probably a family member or close friend or someone you've done business with a long time. You just kind of call up, they give you money. And they're just kind of give you, and it's private money. Hard money lender is probably someone who does it more professionally or more to more people, had made more of a business out of it. So that's really the difference between private money and hard money, even though it's still the same thing. It's all private money. It's not coming from a conventional lender, conventional bank, or institutional bank of some sort. So a lot of my investors have these private money lenders, and the private money lenders don't want to do anything. They just want to get some interest on their money. And they leave it up to the borrower, their investor friend, to actually create these documents, or tell the title company to create these documents, which really becomes an issue because the borrower is creating the documents that are supposed to be protecting the lender. So be aware of that. If you're a lender, or if you have a private lender, have your private lender call me up. We'll do some form documents that they can use over and over and over again. And then they know what's in the documents. They know they're good. They know they're going to be secure. They've got the right instructions, and they don't have to rely on their borrower to create these documents for them, because there's a real conflict of interest there. And as title companies, and many title companies will create notes and deeds for you, very basic, generic ones. But again, it's usually the borrower that's asking the title company to create the note and deed when it really should be the lender. So that's kind of my plea to you private lenders out there, or sort of casual lenders out there. Please kind of get some documents that you can use and provide rather than leaving it up to your borrowers. Okay, we're going to close out with some licensing issues. Probably not spend a lot of time. The question is, do you need a license to be a hard money lender? The answer is possibly yes and maybe no. And I know that's not the answer you want to hear. The real estate industry statutes here in Utah are extremely broad and they're extremely vague. And the Division of Real Estate is tasked by law, they have the legal authority to interpret and enforce the statute. And they do have a tendency to enforce them as broadly as possible. And they do have a tendency to enforce them broader than I believe the statute allows. But again, that's their job. And the only way to challenge that would be to go to court. And most of the fines associated with, doing something without a license are pretty minimal. And no one's going to spend 50 to 100 grand to go to court and challenge something for a $500 to $2,000 fine. And they know that. So specifically with hard money, you must be licensed if you do a closed-end loan. What's a closed-end loan? It's just a fixed amount. It's not a revolving line or a HELOC or anything like that. It is a set amount. So if you provide a closed-end loan, you secure it in a first position. Okay, so it does not include second position loans. So second lenders out there that do rehab money in second position, you're fine. So you got a closed-end loan in first position deed attached to a dwelling. Now, if you're a hard money lender, of course, you're almost certainly doing a closed-end loan. You almost certainly want to be in first position. So the question becomes, what is a dwelling? By definition in the statute, a dwelling is any 1 to 4 unit condo, co-op, manufactured, or single-family residence. Okay, single-family home. And almost certainly, that's what we're talking about. You're going to be loaning on a condo, a co-op, a trailer home, or a home. Okay, so that's, again, a check. Closed-end loan, check. First position, check. Condo, co-op, or home, check. And that this is used as a residence. That's what the statute says. So the question becomes now, what is a residence? Is this property being used as a residence? Well, if it's a flip, I would argue no, it's not being used as a residence. So I don't need a license to do a loan. It's unoccupied, it's being rehabbed. I made the loan so that the investor could do it for rehab purposes, not to rent it out, and it's not being used as a residence. So in that sense, I would say no, you do not need a license. Now, what might the Division of Real Estate argue? They might argue that this is a house. Its purpose is to be lived in as a residence. Therefore, all homes are subject to the licensing requirement because they might be, or they're potentially be used as a residence. So what most hard money lenders do here, and again, it might be a capricious enforcement by the division. They may or may not say it. There are plenty of hard money lenders out there who have been doing this for decades. Most hard money lenders that do this and do it on a regular basis provide disclosures to their borrowers. And it's an affidavit that says that the borrower is doing this for investment purposes, that they will not live in it, that they will not rent it out, that they will not allow anyone to live in it or be used as a residence. The purpose of this loan is for the increase in value by rehabilitating the property and not to be used as a residence. So it's kind of a CYA, cover your document to protect yourself. But remember, if the division decides that any home is technically a residence, even if nobody's living in it, those CYA documents probably won't help. Because it is the division's authority to define these terms and to define them the way that they choose. Clients that kind of have been brought in, essentially you kind of, they push back, they show them these documents, they say that this wasn't a residence, no one ever lived in it. And I've seen times when sometimes the division will back down. While they may be overly aggressive in enforcement, they are still also a little bit reasonable, and they're really just trying to protect the public. And if nobody's hurt, hopefully that no big deal will come of this. There's not a lot of answers in the licensing because it is so vague and ambiguous, and it is seemingly it's enforced differently. And so my suggestion is always to be, jump through all the hoops that you can, do all that you can to comply, do what you need to do, get whatever CYA documents you need, make sure you're covered as you can, and if something happens, something happens. I don't know if it's to the point of where I would completely not, stop doing it. So it really is, it's kind of a personal decision. It's like I said, the answer is possibly yes, maybe no, and whether you're not a hard money lender who does first position deeds needs a license. There is an exception to the licensing that if you make these first position note and deeds on a dwelling, so you actually would need a license, that you can do these if you're not in the business of doing these. If you did one hard money loan every now and then, one a year, one every 2 years, my guess is you're fine because you're not in the business of doing hard money loans. But if you're doing multiple of these a year, then my guess is they're going to say that you are in the business of doing first position deeds on homes, and we're going to call all these homes residences, so you need a license. The business exception, like I said, so if you do very few, this works great for seller financing, because someone asked, would a seller, if a seller finances their house, technically they're giving a first position note and deed on a dwelling for someone who's going to live in it. That certainly falls within the licensing statute. But a seller who's doing seller financing, they're only doing their one house. Most seller financers only have their one house. So they're certainly not in the business of doing it, and they're fine, and they don't need a license to sell or finance their own house. Now, if you're an investor with lots of properties, maybe you own lots of rentals free and clear at this point, and now you want to start seller financing them out, that seller financing could also, almost certainly, if you're seller financing to retail buyers, people who are going to live in the house, that certainly would probably come under the licensing statute. So it's 1 o'clock and we're done. So I will stick around for a little bit longer if anyone wants to type in questions. Again, sorry, got a couple other things I do want to, there. Why does that always happen? Upcoming events, Ken is going to do a special webinar on May 12th at noon. That's a Tuesday in a couple of weeks. It's a primer on the 4 types of LLCs, a standard LLC, a series LLC, a disposable LLC, and an S-elected LLC. It's a great prep class for our next series of 3 webinars, which are on complex entities and asset protection, advanced asset protection modules, which is the webinar, the 4th Friday webinars in June, July, and August. So we'll be sending out information on those, just to keep you posted. If you want a hard money lender in your back pocket, this is actually a great event I got coming up. It is a live class, calling it the Self-Direction Super Class. It's on Saturday, May 30th, about 5 weeks, 9:30 to 1, so it's 3.5 hours. It'll be at the Larry Miller Center in Sandy. It's only $100, and I'm telling you, if I teach this again next year, it's not going to be under $300. This may be streamed live nationally. This is information that you really cannot find anywhere else, because I searched for years to find this kind of information on self-directing IRAs and 401ks. You get little bits and pieces here and there. You can get sales pitches from custodians to put your IRA money with them. You sales pitches from lawyers that are selling IRA LLCs, where you get kind of all the happy, glossy stuff to kind of get you motivated and pumped up to do this self-direction with your IRA, but you're not getting all the information. You're not getting information on the UBIT taxes. You're not getting information on prohibited transactions. You're not getting information on how to structure the deal with LLCs and to protect both your IRA and yourself. You're not given the instructions on step-by-step on actually how to make this happen. And in this 3.5-hour class, that's what we're going to do. It will fill up, absolutely. There's no question in my mind at $100, it'll probably fill up in a week or so. And then I'll have to decide what to do after that, if we're going to get a bigger event venue or something. But honestly, this is a great, great class. Saturday, May 30th. It's only $100, 3.5 hours. That is cheap education. And like I said, I really doubt I'll ever do this class again because it is a very highly specialized class that you just can't find anywhere else. So highly recommend to register for that. Remember the free webinars, because again, we all love free education. Ken's free webinar Tuesday, May 12th, and our next series of 3 webinars in June, July, and August on complex entity and asset protection. If you need hard money documents, also feel free to give the office a call. We're happy to get stuff set up for you. We can do stuff on a per transaction basis, or we can create form documents that you can use over and over and over again. So anyways, that's great. If you need to sign off and get back to work, knock yourselves out. Go have a great day, have a great weekend, go make lots of money. I'm going to stick around and answer some questions. Okay. See you, everybody. We're going to turn off the recording.